All right, my name is Dr. Robert Greene II, the lead instructor for the Modjeska Simkins School of Human Rights. And today, on June 8th, we are celebrating, along with colleagues and comrades from across the country, National Teach Truth Day. Of course, right here in South Carolina, the Palmetto State has a rich history of activism, of fighting for human rights and social justice. Unfortunately, so much of that history is not very well known, even within our state. And right now, as we speak, there is plenty of legislation at the State House trying to strangle the ideas and traditions of history right here in the Palmetto State. What I can tell you, with the students of the Modjeska Simkins School of Human Rights of the South Carolina Progressive Network, there is a lot of work being done, even as I speak, to keep this tradition and this history alive. We are, of course, right in front of the Modjeska Simkins House, a house which is storied with plenty of history for Black Americans, for all Americans of all types. Modjeska herself, of course, was a stalwart champion of social justice and human rights. And it was here in 1948 that NAACP lawyer and future Supreme Court Justice Thurgood Marshall began writing down plans for the Briggs v. Elliott case, which of course is best known today as being part of the Brown v. Board of Education decision of 1954. But this human rights history, this human rights tradition, of which South Carolina is an important part of, is under siege even today. Right now, there's legislation in place in South Carolina designed to restrict how we talk about race, culture, and difference in K through 12. Right now, African American Studies as an AP course is under severe threat here in South Carolina. But I rest assured in the fact that the students of the Modjeska Simkins School of Human Rights are fighting to make sure that this history is kept alive in the Palmetto State. In South Carolina, we have a history of fighting for social justice, for civil rights, and for human rights. From Robert Smalls to Modjeska Simkins, from Septima Clark to so many others. We here at the Modjeska Simkins School of Human Rights know that South Carolina is a place where freedom and justice can live for everyone, not just a privileged few. The key here is to teach this history and to keep this history alive, no matter the cost. So on National Teach Truth Day, I encourage all of you out there to make sure you learn about the history of South Carolina, the United States, and the entire world. Because together we can keep that history alive, and together we can make a difference. Thank you. You know, when it comes to the Brown v. Board of Education decision, I think most Americans know what the decision decided, that Plessy v. Ferguson, the idea of separate before equal, was actually unconstitutional. What most Americans may not be aware of, however, is two things. Number one, that Brown v. Board was actually an omnibus case. It was actually several cases rolled into one under the Brown v. Board title. And secondly, that the first case in those omnibus cases was actually Briggs v. Elliott, which was the case from right here in South Carolina. Now, the Briggs v. Elliott case was argued by Thurgood Marshall, the NAACP, and the case had its origins in Clarendon County, South Carolina, where Harry and Eliza Briggs were essentially trying to get school buses for Black students in Clarendon County. Their whole argument was that if the state is serious about the idea of separate but equal, then we should have an equal number of school buses. We should have an equal quality of schools and education and the like. They weren't originally fighting to destroy segregation. They were simply saying to white South Carolinians in the state government, hey, actually live up to the equal part of separate but equal. Most of the white South really emphasized the separate part, whereas Black Americans were saying, can you at least hold up the equal part? Now, the thing about Briggs v. Elliott was that the NAACP, when it argued the case in the early 1950s, realized that it was part of a much larger assault on segregation across the South. By that point, in the 1930s and 40s, the NAACP had successfully won several cases arguing for equalization in terms of graduate schools, law schools, and the like. So backtrack for a second. In 1946-47, right here in South Carolina, John Wrighton, a black student, tries to segregate the law school at the University of South Carolina. In Wrighton versus the USC Board of Trustees, it's decided by the federal court here in South Carolina that they don't have to let him in, but to live up to separate but equal, they do have to create a separate law school for black students, which is actually founded at South Carolina State College. And I'm actually wearing their hat today. Sheer coincidence. I actually work at Claflin, but I digress. But when Thurgood Marshall argues the Briggs v. Elliott case in front of Judge Wade's Waring here in South Carolina, Judge Waring tells him, well, perhaps you should think about more than trying to push for the equal part of separate but equal. Perhaps you should push for full-throated desegregation across the board. And this really becomes what the Brown v. Board case ends up deciding in 1954. However, and this is something that more historians have begun talking about, in an omnibus of cases, usually the case that is in alphabetical order first is the case after which the larger omnibus of cases is named after. Briggs comes before Brown, I before O. And there's been some debate about why the case is nationally known as Brown v. Board and not Briggs v. Elliott. One leading theory is that James Burns, who was in the early 1950s governor of South Carolina, but before that was a congressman, a senator, a Supreme Court justice, Secretary of State. He was a, shall we say, a pretty big wig within the Democratic Party. There's a theory that James Burns pushed his friends in the Supreme Court to call the case Brown v. Board so as to not further antagonize the South with a decision that would overturn segregation. Right? Because remember, Brown v. Board is actually out of Topeka, Kansas. And so there are many who believe that that's the reason why it's called Brown v. Board and not Briggs v. Elliott. But right now there's a movement underway to actually get the case name changed to Briggs v. Elliott to give recognition to the folks in Clarendon County, because it's important to note that it wasn't just a case, it wasn't just a legal decision. Folks in Clarendon County who were trying to get their kids equal education, equal school buses and the like, they lost their jobs, lost their livelihood. Modjeska Simkins herself led a national effort to provide food and relief to those men and women who lost their work and livelihood in Clarendon County. This was a case that really changed their lives permanently. And as we look at how South Carolina even now often ranks dead last or close to last in many educational standards, we would do well to remember why generations before folks were fighting for equal education in South Carolina. That fight is actually not over, but the idea of Briggs v. Elliott being an important watershed moment in U.S. history is one we should latch on to and continue to uphold and uplift. And answer your question.